Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, we have already discussed previous year papers of several states, and from today's video onwards we are starting the series for Jharkhand Judicial Services. Now, as you know that notification for Jharkhand Judicial Services 2023 has been released by the Jharkhand Public Service Commission, and we have also made a short, and the advertisement you can see in our shorts videos and also on our Instagram channel. And in today's video we are going to discuss the preliminary exam paper of Jharkhand Judicial Services 2018 which was held in 2019. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज़. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो लेट्स मूव टू द क्वेश्चन पेपर. सो द पेपर कम्स लाइक दिस. सीरीज ए 2 hours 100 marks. बुकलेट क्वेश्चन प्री. यू हैव टू फिल योर रोल नंबर हियर. नो नेगेटिव मार्किंग. I have downloaded this paper from Jharkhand Public Service Commission websites. You can also download it from there. And if you Google search this paper, several websites are showing it as paper of 2019. However, this paper was of 2018. Advertisement was released in 2018 and exam held on 27th May 2019. Maybe that's why they are mentioning it as 2019. And I could not find this paper on any website. Some websites are showing the paper in Hindi, but that is also not full paper because the English version is not there. So if you could not find this paper anywhere, just look for this at our Telegram channel. You can find it over there. And friends, I am going to discuss this paper in English and also in Hindi. The English part would be the same, the first 10 questions obviously, and the 90 question English part and Hindi part I will discuss it separately. So you can just look at the playlist of Jharkhand English and Jharkhand Hindi. Question number 1 is choose the correct meaning of underlined phrasal verb in the following sentence. So 1 to 10 question are from English, and this is the pattern of this exam. This question has been deleted. How? The options were not correct. His evidence beans out the testimony of the accused. Beans out, what is the meaning of beans out? To reveal a hidden thing. मतलब means जब कुछ चीज़ hidden हो और उसको reveal कर दे तब उसको बोलते हैं beans out. मतलब आपने पता निकाल लिया, उसका पता लगा लिया. तो corroborates क्या होता है? मैच करना, मिलान करना जो बोलते हैं. falsify, no, does not support, no, contradict क्या होता है? उसका खंडन करना. Alright. So this question was deleted. Next is to choose the correct spelling. Encyclopedia. So encyclopedia. B is the answer. Next is 3. Which word is personification in this sentence? Death lays its icy hand on kings and paupers alike. Personification किसका किया गया है? Death. C is the answer. Next is 4. Choose the word closest in meaning to the underlined word in the sentence. I sat next to a distinguished writer. Means well known, eminent. क्या बोलते हैं इसको? Eminent. B is the answer. Which is not common, means extraordinary person. Uncommon. B would be the answer. Next is 5. Choose the correct indirect form of the following sentence. He said to me, let's have some tea. So what would be the indirect? He proposed to me that we should have some tea. B is the answer. Next is 6. Choose the tense form of the following sentence. The patient had died when the doctor arrived. This is past perfect tense. C is the answer. Next 7. Orthopedics is the branch of medicine concerned with स्टडी ऑफ ह्यूमन बोन्स एंड मसल्स, सी इज द आंसर। स्टडी ऑफ ह्यूमन स्किन को क्या बोलते हैं? डर्माटोलॉजी, है ना, डर्माटोलॉजी। एंड ह्यूमन नर्वस सिस्टम, न्यूरोलॉजी, न्यूरो होता है ना, आइज एंड ईयर, सी आइज के लिए है ऑप्थमोलॉजी, ओके, एंड ईयर के लिए है ओटोलॉजी। This is 8. The word most opposite in the meaning of the word amateur is professional. A is the answer. What is clumsy? होता है ना, ढीला सा है, ढीला ढाला, ढीला जो बोलते हैं नॉर्मल भाषा में, मतलब लेजी। अनस्किल्ड हिंदी में बोले तो अकुशल। टैलेंटेड आपको पता ही होगा। This is 9. Choose the correct meaning of underlined word in the following sentence. Trespassers will be prosecuted, मतलब will be punished. Legal action will be taken against them. C is the answer. Harass नहीं होगा, punish unjustly नहीं होगा, oppress नहीं होगा. Legal action will be taken. C is the answer. Next is 10. Choose the correct meaning of the underlined idiomatic phrase in the following sentence. He was sent off on a wild goose chase to look for buried treasure. What do you mean by wild goose chase? It is not a bird hunting, not. It is not a profitable adventure, not a treasure hunting. It is foolish, unprofitable venture. Means इससे कुछ निकलना नहीं है, but फिर भी उसको भेज दिया करने के लिए. A is the answer. This is 11. According to 2011 census, which of the following is least populous state in India? That is Sikkim. B is the answer. This is 12. Which one of the following is a tiger reserve in Jharkhand? That is Palamu. C is the answer. Next is 13. Which one of the following classical dance forms is mainly associated with Andhra Pradesh? It is Kuchipudi. C is the answer. Bharatnatyam, Tamil Nadu. Kathakali, Kerala. Mohininatyam is also from Kerala. C is the answer. Next 14. Under GST taxation framework, CGST means Central Goods and Service Tax. B is the answer. A very common question, very easy questions. Next 15. Which of the following is a national monument of India? See, there are several national monuments and these all are national monuments. So this question was also deleted. Next 16. Which one of the following Indian cities is known by nickname of Deccan Queen? It is Hyderabad. Is Pune. B is the answer. Next 17. Who among the following is the first woman chief minister in the post-independence period in India? She was Sucheta Kriplani. C is the answer. She was the first woman chief minister of UP. After that, Nandini Satpathy became the chief minister of Tamil Nadu. So C is the answer. Next 18. Who among the following is the first chief election commissioner of post-independence India? That was Sukumar Sen. B is the answer. Next 19. Which of the following are the official languages of International Court of Justice at Hague? That is English and French. D is the answer. This is 20. International Yoga Day is celebrated on 21st June. Everybody knows that. C is the answer. Now the law part starts from here. Question number 21. A deposits a box of gold coins with B as his agent. He then writes to C for the purpose of making the gold coins as security for a debt due from himself to C. A afterwards alleges that C's debt is satisfied and C alleges the contrary. Both claim gold from B. B may institute and interpret a suit against A and C both. D is the answer. There is a provision for interpleader suit, that is section 88 and order 35 CPC. Next is 22. A foreign judgment, where it is defined in section 26 of CPC. Can never be conclusive, or it can be conclusive as to any matter indirectly adjudicated upon between the same party. No, as to matter directly adjudicated upon between the same parties if it has not been pronounced by a court of competent jurisdiction. No, if it has been pronounced by a court of competent jurisdiction. D is the answer. Section 13 mentions about this of CPC. Next 23. A bank officer got compulsory retire in 2014. Since the bank authority did not release the leave encashment in his favor, he filed a writ petition so and so in Ranchi High Court for the same and also for the interest unpaid amount. But disposed of in London single judge in December 2018, directing the bank to release the privileged leave encashment benefit to the petitioner to the extent he was entitled in accordance with the law with a certain period. The prayer for interest was not specifically denied by the court. The bank filed an appeal against the order. The division bench Ranchi declined to admit the appeal. The bank authorities leave encashment in favor of the petitioner. However, A files a writ petition again for direction to the bank to disperse interest to A at the rate of 18% per annum on the leave encashment. This petition is covered under which of the following? Under section 11, explanation 5, B is the answer. What explanation 5 says? Any relief claim in the plaint which is not expressly granted by a decree be deemed to be refused. It is deemed refused. B is the answer. Next 24. On the reversal of a decree, which section imposes an obligation on the parties to the suit who received an unjust benefit of the erroneous decree to make restitution to the other party for what he lost? Section 144. D is the answer. Next 25. Interveners are not entitled to be. Are they entitled to be pleaded? या फिर not entitled? Not entitled. B is the answer. Waste of time, burden of plaintiff. No. B is the answer. Next 26. Suit for recovery of money in promissory note can be filed under summary procedure as laid down in Order 37 CPC. B is the answer. Next 27. Inherent powers of civil court are exercised to make such order as may be necessary for the ends of justice. Totally correct. To make such order as may be necessary to prevent abuse of the process of the court. This is also correct. Both A and B. C is the answer. And where is the inherent powers mentioned? Section 151 CPC. Next 28. In the case of public nuisance, a suit for declaration and injunction may be instituted by two persons with the leave of the court. This is correct. Two persons having obtained oral consent of Advocate General, no. Written consent of Advocate General, no. To whom no special damage has been caused to the person of such nuisance, no. A would be the answer. And where this is mentioned, it is mentioned in section 91 CPC. Next 29. Section 20 CPC does not apply to arbitration proceedings. A is the answer. Civil proceeding में तो apply, it would apply. B is the answer. A is the answer. Next 30. Pleadings can be altered or amended under Order 6, but which rule? 17. D is the answer. Next 31. A defendant can pray to the court for rejection of plaint if the stamp writing is not clear or if it is barred by another enactment of the parliament. It is barred by any law. B is the answer. Where this is mentioned? It is mentioned in Order 7, Rule 11 and its clause D. Next 32. Where the local limits of jurisdiction of the court are uncertain, the place of institution of suit shall be decided according to section 18. B is the answer. 18 CPC. Next 33. In the execution of a decree for the maintenance, salary of a person can be attached to the extent of 2/3. C is the answer. Section 60 CPC mention what cannot be attached, and it is mentioned 1/3 salary in maintenance cannot be attached. So 2/3 can be attached. C is the answer. 34. A foreign government can be sued या फिर can be sued without any restriction on the power of civil court या फिर can be sued with the restriction that the oral consent, no. Written consent, sued with the condition that a certificate of the consent is issued by secretary to the central government in writing. D is the answer. It is mentioned in section 86 CPC. Next 35. Which of the following is not a sufficient cause for granting adjournment? Sickness of a party, his witness or his counsel? No. Non-examination of witness present in a court? Yeah, this can be. Reasonable time for preparation of a case? No. Non-service of summons? No. D is the answer. And where is the provision for adjournments? Order 17 CPC. Next 36, CRPC was last amended on, they are asking about the amendments. So the last amendment which came in 2018 came on 11th August 2018. C is the answer. And this was the date of notification. However, it gave a retrospective effect from the date 21st April 2018. Next 37, CRPC contains 484 sections. D is the answer. This is easy question. How? 482 is the inherent powers of the High Court, and all sections are below that 482. Only one option is there. Next 38, FIR can be quashed by a High Court on the ground parties having arrived at settlement no heinous offence was committed according to the charge sheet. It is correct. The parties having arrived at that settlement and heinous offence was committed, no. Serious financial fraud was committed, no. Without any ground, no. A can be the answer. And under what provision? Under section 482, inherent power of High Court. And 39, a magistrate may dispense with personal attendance of accused under 205 CRPC. B is the answer. Next 40, if the evidence is available about a person who appears to have committed an offence but his name is not mentioned in the charge sheet as accused, his name can be added by judicial magistrate or session court, or cannot be added. A name can be added by the High Court, Supreme Court, no. The judicial magistrate or session court can add his name. A is the answer. Under which provision? Section 319 CRPC. Next 41, which of the following statement is correct? A police officer has the power to require attendance of a witness under the age of 15 years before himself. No. He cannot ask for attendance of a person below 15 years and above 65 years, or woman. This is the attendance of woman, also wrong. 65 years or wrong. Does not have power to attendance who are mentally. This is correct. D is the answer. This is section 160 CRPC. Next 42, when the injury or trial relates to an offence committed under section 376 CRPC, the inquiry or trial shall be concluded within the period of. Now I would say this question is wrong. How? This is IPC, not CRPC. It is mentioned an offence committed under section 376 IPC, and such inquiry or trial shall be completed within 2 months after filing of charge sheet. It is mentioned in section 309 proviso. So I would say this question should have been deleted. Next 43, rule autrefois acquit and autrefois convict is contained in section 300. B is the answer. It relates to double jeopardy. Next 44, every person is under an obligation to give information about the commission of an offence to a nearest magistrate or police officer for offences under section 121 to 126 and other several sections of IPC, not CRPC. But this is mentioned in CRPC in section 39. So B can be the answer. Next 45, which section of CRPC involves the reciprocal arrangement to be made by the central government with the foreign governments through a treaty with regard to service of summons, warrants and judicial process? See, section 100 is search in closed place. Okay. 103 is magistrate may direct search in his presence. 105A are certain definitions relating to chapter 7A, which is a reciprocal arrangement. Okay. And 104A is just nothing. I would say these options are also not correct, not proper. How? They're asking about the section and there is no particular section mentioned this. However, there is only definition section of 105A, in which definition of contracting state is also mentioned in clause A of 105A. So I would say this question is not proper, but reference can be given to C. Next 46, a woman can claim maintenance from her husband if she lives in adultery. No. If she refuses to live with her husband. No. If she lives separately by mutual consent. No. If she is neglected, then yes, she can claim. D is the answer under section 125 CRPC. This is 47. A magistrate can ignore the conclusion reached at by the investigating officer and apply his mind independently. Yes. Not ignore the conclusion. You have to ignore the conclusion reached by the IO and apply his mind independently only upon statement of witnesses recorded by the under any circumstance. Not ignore under any circumstance. No. So A is the answer. Next 48. A statement made by any person to a police officer in the course of an investigation can be used for any purpose. या फिर cannot be used for any purpose except for the purpose of contradicting a witness. D is the answer. This is mentioned in section 162 CRPC. Next 49. When the court of session passes a sentence of death, then the proceedings are submitted to the High Court and death sentence is executed. No. Proceedings are submitted to the High Court and death sentence is executed only after the confirmation by the High Court. Yes. So, in which provision you submit for confirmation under section 366, and power of High Court to confirm is provided in section 368 CRPC. Next 50. Anticipatory bail is granted by High Court or Court of Session in anticipation of arrest in non-bailable cases. Yes. In bailable cases, no. Bailable है तो bail तो मिल ही जाएगी. फिर by passing a regular court which had to try offender no ordinary circumstances, no. A is the answer. Provision in section 438 CRPC. Next 51. The maxim quando lex acquilit aliqui concedit considere vedatur it sign quaere ipsa esse non potest is enshrined in section 482 CRPC. C is the answer. What it means? इतनी लंबी मैगजीम है ये, क्या मीनिंग है इसका? This is a Latin phrase. The meaning of it is whoever grant a thing is deemed also to grant that without which the grant itself would be of no effect. Next 52. Opinion of handwriting expert under the law of evidence in India is relevant but not relevant, no. Relevant and sole determinant, no. Relevant but not sole determinant of genuineness of document. C is the answer. It comes under expert opinion under section 45 Evidence Act. Next is 53. Under section 90 of Indian Evidence Act, presumption as to all document of 30-year-old, it should have been a document 30-year-old. The relevant date of computation of that document in the court is date of production of document in court, या फिर date of initiation of proceeding in which document is produced, no. Date of oral evidence by witness, या फिर date of hearing. Date of production of that document in court in evidence. This should have been a proper statement. The date of initiating of proceeding in which document is produced. So let's say that proceeding initiated in January 2018. Now the document is given in 2020. So shall you compute that from here or from the starting of the proceeding? How does it matter? Whenever you give the document in evidence, the computation shall start from there. So A could be the answer, but this is also not properly mentioned, and this is also not proper. Next is 54. Tape recorded a conversation is admissible in evidence if conversation is very important. No. Conversation can save the culprit. No. Conversation is relevant to the matter in issue, but the voice is unidentified. No. It must be relevant and voice shall also be identified. D is the answer. Next 55. The evidence relating to conspiracy is common motive of the conspirator and any act done in pursuance of it, या फिर common intention, या फिर common of the conspirator and anything in writing in pursuance of it. Common intention of the conspirator and anything said or done, written by any of them in furtherance of that intention. This is perfect. C is the answer. And where the provision relating to conspiracy, evidence relating to conspiracy, section 10, Evidence Act. Next 56, test identification parade is a corroborative evidence. B is the answer. It is not a substantive evidence. And where in which provision you do test identification parade? Under section 9, Evidence Act. Next 57, the presumption under section 114A is a rebuttable presumption. A is the answer. What is 114A? Relating to presumption of consent in rape cases. Next 58, which section of Indian Evidence Act deals with the proof of customary practices? It is 35, 48, 49. D is the answer. Next 59, the court shall not take judicial notice of geographical divisions of world. It will take public festival notified, official gazette, yes. National flag of foreign country recognized by government of India, yes. Official signature whose appointment is not notified in official gazette, no. D is the answer. And you can see section 57, 58 for that in Evidence Act. Next 60, the content of a document may be proved either by primary or by secondary. D is the answer. Where this is mentioned, it is mentioned in section 61 of Evidence Act. Next 61, A agrees in writing to sell a horse to B for rupees 1000 or 1500. So evidence cannot be given to show which price was to be paid for sale. This is correct. Can be given, no. Cannot be given, show the average of the sale price, no. Average, no. So A is the answer. And where this is mentioned, it is mentioned in section 93 of Evidence Act, and this is illustration A in that section. Next 62, public officer cannot be compelled to disclose communication made to him in official confidence if he does not consider that public interest would suffer by disclosure. This is wrong. Cannot be compelled to disclose communication made to him if he considers that public interest would suffer by that disclosure. B is the answer. And this is section 124 Evidence Act. Next 63, an accomplice is not a competent witness against an accused person. No, this is wrong. He is a competent witness against accused person and must be corroborated. In that case, he must be prosecuted. Is a competent witness. B is the answer. It is mentioned in section 133 of Evidence Act. It talks about accomplice. Next 64, examination in chief means examination of a witness by a party who calls him, not adverse party, not CGM, not superintendent, not chief SP. D is the answer. Examination in chief, cross-examination and re-examination. There are three types of examinations mentioned in section 137 Evidence Act. Next 65, a judge in India is not empowered to put caution of his own. No, he is empowered to put caution on his own to the witness or parties according to his sweet will, or on his own to the parties in order to discover, obtain proper proof of the relevant fact. This is perfect. C is the answer. To Indian common law doctrines, no. C is the answer. And section 165 Evidence Act. Next 66, the difference between section 34 and 149 CRPC is that in section 34 there must be at least 5% no. It is vice versa, 2 in 34 and 5 in 149. This is wrong. 149 is a rule of evidence, whereas section is specific offense. This is also vice versa. 34 is a rule of evidence and 149 is specific offense. Then requires active participation in action, whereas 149 requires mere passive membership of unlawful assembly. This is correct. Then need not be joined principal offense, whereas section 149 be combined with the principal offense. This is wrong. C is the answer. 34 is common intention and 149 is common object. Next 67, A takes a girl out of the custody of her lawful guardians. The following statement is complete defense if A is charged under section 361 IPC for kidnapping on the ground that girl was below the age of 18 years when taken away. तो डिफेंस बताना है यहाँ पे. द गर्ल वाज स्टूडेंट इन कॉलेज एंड कुड अंडरस्टैंड व्हाट द राइट और रॉन्ग, या फिर गर्ल वाज मेल ट्रीटेड बाय द गार्जियंस, या फिर गर्ल लुक्ड मोर देन 18 ईयर ऑफ एज एंड accused had satisfied himself that she was more than 18 years of age. Even all these are satisfied. There can be no excuse if she is less than 18 years of age. So D would be the answer. Next 68. Y picks X's pocket. Next day, X, while buying pan near his office, finds Y paying money from X's purse. X catch hold of Y and tries to take back his purse. Y resists. X twists Y's arm in such force that it is broken. X is charged with causing hurt to Y. X can say that he was acting under the private defense of property. No, Y cannot raise the plea of right to private defense since he had time to seek help of public authorities. Exception आ गई ना RPD की. When you have time to recourse for the public authority, then you cannot exercise your right to private defense. B is the answer. Next 69. Consider the following statements. A person is not guilty of dacoity unless he has committed, attempted to commit, or aided in committing robbery. Yeah, this is correct. When two persons conjointly commits robbery, every person so committing robbery is said to commit robbery. This is also correct. Both are correct, both are true. A is the answer. First, there must be robbery, and if there are 5 persons, then it becomes dacoity, obviously. And one person is doing robbery and another is assisting him, and obviously both have done the robbery. Next 70. Under which of the following situations would the Indian courts have jurisdiction? Crime committed by an Indian in a foreign country, yes. Crime committed by a foreigner in India, yes. Crime committed by a person on an Indian ship, yes. According to section 3 and 4 of IPC, all are correct. D is the answer. 1, 2, 3 are correct. Next 71. If actus non facitarium nisi mansitria is cardinal principle of criminal law, then which one of the following statement correctly reflects the above principle? Mens rea is an essential element of a crime and there cannot be crime without mens rea. This is a general statement. However, there are some crimes such as this kidnapping, just did the question, and bigamy, and there are several other offenses. Then criminal liability under Indian law always implies mens rea. Not necessary. To constitute a crime, there must be actus reus and mens rea. This is correct. Actus is not always necessary. No. C is the answer. C is perfect one. Next 72. A, having delivered money to his servant to carry out a distant place, disguise himself and robs the servant on the highway with an intent to charge him. A commits the offense of robbery or what? Obviously C is the answer. Next 73. X, with a view to murder Y, enters Y's bedroom at night when Y is out of station. X is guilty of, this must be housebreaking by night under section 446. However, the mentioned options are only house trespass. So you can say house trespass, but this is not a correct answer. This is not the correct option actually. Next 74. Which one of the following is sufficient to prove the offense of sedition? Comment expressing disapproval of the policies of the government with a view to obtain a change in policies of by lawful means. This is not. Proof of disloyalty, ill-feeling, no. Comment expressing disapproval of administrative action even though these do not excite hatred, no. Exciting disaffection towards the government. However, this provision has now put in abeyance by decision of Wombat-Kere versus Union of India. This is decision of year 2022. Where is the provision? 124A IPC. Next 75. Which one of the following conclusion can be drawn from maxim de minimis non curat lex? Necessity knows no law. No. Nothing is an offense done by child under 7 years of age. This is doli in capax. Every person is liable for his own act. Triple acts do not constitute an offense. D is the answer. This relates to section 95 IPC. Next is 76. Which one of the following cases pertains to misuse of section 498A IPC? So the answer is Priti Gupta versus State of Jharkhand. B is the answer. Next 77. Which one of the following cases pertains to constitutionality of section 377 IPC? See, Vishakha versus State of Rajasthan is on sexual harassment at workplace guidelines. Alright. And this case was Navtej Singh Johar versus Union of India. C is the answer. Next 78. Which one of the following cases pertains to constitutionality of 497? That was Joseph Shine versus Union of India. A is the answer. And 497 was held unconstitutional. A is the answer. Next 79. Which one of the following cases refers to conspiracy under section 27 of Indian Evidence Act? That is Pulkari Kotaiya versus Emperor. A is the answer. बहुत ही common question है ये तो. Next is 80. Under which section of CRPC a person who is avoiding execution of a warrant may be proclaimed absconder? That is 82. C is the answer. Next is 81. Offer or proposal is defined in which section? 2A of Contract Act. A is the answer. 2B is promise. 2D is consideration. 2E is agreement. Next 82. An agreement not enforceable by law is void. C is the answer. Where is the definition? Section 2G of Contract Act. Next 83. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. B is the answer. This is section 4 of Contract Act. Next 84. Which statement is not true? A proposal is revoked by the communication of notice of revocation by the proposer to the other party, या फिर is revoked by the lapse of time prescribed in such proposal for its acceptance. This is correct. This is correct. Proposal is revoked by lapse of reasonable time if no time is prescribed. It is also correct. A proposal is revoked by not meeting at time prescribed. This is not true. D is the answer. Next is 85. The acceptance must be received within a week, fortnight, absolute and unqualified. C is the answer. This is section 7 of Contract Act. Next 86. Who is competent to contract? Person of unsound mind? No. Who has not attained majority? No. Who has been disqualified from contracting by the court? No. Person who has been debarred from contesting any election. He can do contract. He can do agreement. D is the answer. Next 87. Consent is said to be free when it is caused by coercion? No. Fraud? No. Mistake? No. Voluntary will of the parties. D is the answer. Consent is defined in section 13. Free consent is defined in section 14 of Contract Act. Next 88. Two or more persons are said to consent when they agree, या फिर they agree upon same thing, या फिर they agree upon the same thing in the same sense or at the given location. No. C is the answer. Next 89. When consent of an agreement is caused by coercion, the agreement is voidable contract. B is the answer. This is coercion is provided in section 15 and this is mentioned in section 19 of Contract Act. This is 90. An agreement is void if the consideration is unlawful in part. Yeah, it can be. If the consideration is not provided by the parties, that is obviously it is void. Agreement without consideration is void. But if the consideration is to be given in future, that is not void. If the consideration is paid in the past, that is also not void. So there are two options and that option was not proper. So this question was also deleted. Next 91. An agreement in restraint of marriage is void. B is the answer. See, I have made a formula and each and every single video, whatever exam it is, This question always comes, and I have made the formula like this: CMTLUW, CMT love. So from 24 to 30, all agreements are void agreements in Contract Act. 24 about unlawful object. Okay, so consideration without agreement 25, extent of marriage 26, extent of trade 27, extent of legal proceeding 28, uncertain 29, wagering 30 though. So all these agreements are void agreements. So you can learn this formula, and whenever you're going in the exam, just write it over there in your question paper rough page, because in every question paper you will get a rough space, so you can just go in the exam, just mention it over there. It will hardly take 10 seconds. Next is 92. A contract to pay B a sum of rupees 20,000 if B's house is burnt. This is a contingent contract. B is the answer. And this is illustration in section 31, contingent contract. Next 93. A agreed to pay B a sum of rupees 5,000 if two straight lines should enclose a space. This agreement is void due to impossibility. This is illustration A in section 36 Contract Act. Next 94. A and B make a contract grounded on the erroneous belief that particular debt is barred by Indian law of limitation. This contract is not voidable. It is mentioned in section 21 and the option was not there. This question was also deleted. Next 95. A, who is B's Mukhtar, promised to exercise his influence as such with B in favor of C, and C promises to pay rupees 20,000 to A. The agreement is voidable because it is immoral, या void because it is immoral, या फिर opposed to public policy, या void because consideration is unlawful. Void because consideration is unlawful. D is the answer. This is illustration J in section 23 of Contract Act. Next 96. A paid rupees 10,000 to B for manufacturing a machine. When it is partly manufactured, the contract is discharged by frustration. What is the remedy available to the parties? A can recover rupees 10,000 from B. Obviously, this can happen. B need not pay any further amount to B. This is also correct. B can return 10,000. No. So B is entitled only to the expenses incurred before the time of discharge. This is also correct. So there are three options are correct and one is wrong. So they should have asked like what is not a remedy available. So I would say this question was also wrong. Next 97. Liquidated damages is essentially a payment of money stipulated as a warning to the offending party. No. Payment of compensation determined by the court. No. Compensation arbitrarily determined by the aggrieved party. No. Genuine covenanted pre-estimate of damage. This is liquidated damages. So D can be the answer. But in one sense, if you see, it is also a payment of money, estimate of damage, yes, and stipulated as a warning. If let's say the party A giving warning to party B, by B, if you broke the agreement, you shall pay this amount. So this could also be the answer. Many questions are controversial questions. Next 98. Where there is a breach of contract, special damages are awarded. Alright. In which case? In all cases, no. Only when there is special circumstances, no. When there is special laws, no. Only when there is a notice of the likely special loss. The breaching party knew that the other party would suffer a special loss. Only in that case. D is the answer. Next 99. Now the list 1 list 2 match करना है. Carly versus Carbolic Smoke Ball is a offer at large. Fisher versus Bell is an invitation to treat. Tin versus Hoffman, cross offer. Harry versus Facey, quotation of price. So 1, 2 and 4, 3. A is the answer. Next is 100. Madhukant Pathak versus State of Jharkhand through vigilance was decided by Jharkhand High Court in July 2017 and it pertains to tender. So this was asked in recent cases of 2017-18 है ना. So B was the answer. So keep preparing for the recent cases of Jharkhand High Court as well. So friends, here we have discussed all the questions of Jharkhand Judicial Services 2018 which was held in 2019 and in English. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको ज़रूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.